Welcome to Higher Callings, a podcast featuring interviews of lawyers and other people who, through their careers and volunteer activities, have devoted significant time and energy to serving the common good. My name is Donald Frederico. I'm an experienced litigation attorney with a practice in Boston, Massachusetts. Through my work as a lawyer and my leadership positions in several nonprofit organizations, I've had the privilege over the years of meeting and working with many amazing people who have dedicated significant time and energy towards serving their communities and their professions and helping people in need. My hope is that by shining a light on some of these people and their good works, Higher Callings will inspire others to find their own paths towards making the world a better place. I am delighted that the first guest on the podcast is David Hoffman. Almost 20 years ago, David left a prominent Boston law firm to form the Boston Law Collaborative, where he serves as a mediator and alternative dispute resolution professional. He also is a lecturer at Harvard Law School, where he teaches a course on mediation and other courses on related topics. David brings a philosophy and style to alternative dispute resolution that sets him apart from many ADR professionals. It is a style that allows him to truly connect with the people who appear before him and to attempt to bring some degree of healing to the dispute resolution process. A few years ago, David gave a TEDx talk called Lawyers as Peacemakers, which should give you a sense of the values he brings to his practice. We cover a lot of ground in the podcast, starting with some of David's early influences, including the civil rights movement of the 1950s and 1960s, the anti-war movement of the 1960s and 1970s, and the South Africa divestment movement of the 1980s. We also talk about David's very unusual career path, and about the variety of forms and theories of alternative dispute resolution that he applies in his work. I really enjoyed talking with David and found his story to be fascinating. I hope you enjoy the podcast, and thank you very much for listening. Hello, David. Thank you for being here. I really appreciate it.
Hi. Yeah, good to be here. So first of all, I just want to say it's a real honor to be invited to be part of your podcast. I particularly like the name of your podcast, Higher Callings, and I know we'll get into that theme in our discussion.
Let's talk about your background, and then later we'll launch into more of a conversation about mediation and your philosophies about dispute resolution and things like that. But you grew up in Baltimore.
Yes.
And you were, I think, a self-described product of the 1950s and 1960s.
True.
During the civil rights movement, the anti-war movement. Can you talk a little bit about those formative years and how what was going on in the United States at the time influenced you and helped form you as an adult?
Sure. Baltimore was and remains a very segregated city. And as I first became aware of news and what was going on in the world around me, Brown versus Board of Education had been decided. There were struggles over desegregation, not only of schools, but places of employment, housing, etc. And my parents were liberal. They weren't political activists by any means, but they espoused values of integration and equality. However, I was surrounded, as I looked around Baltimore, by the vast disparities in wealth and opportunity that existed based on race. And also, as I became a little more aware, maybe by the time I got to college, about gender discrimination and other kinds of discrimination. But the primary shaping influence for me growing up from the time I was, about 7 or so, was the civil rights movement, and later in my teen years, the anti-war movement. And the developmental psychologists say our ideals are formed at that stage in our life. And I feel indelibly imprinted with the values that my friends and I uh, received from our rabbi, from walking the picket lines with the Congress of Racial Equality in Baltimore, and from the effort to stop the war in Vietnam.
That actually leads to my next question. As you came of age in your high school and college years, did you get involved in any of the activities that were going on at the time?
I did. My friends and I started marching picket lines in 1962 in downtown Baltimore to pressure the department stores there to hire people of color. And in my final year of high school, which was 64, 65, I formed an organization called High School Students for Peace. And we demonstrated at the Federal Building in Baltimore. Um, of course, they were tiny protests compared to what was going on down the road in Washington, D.C., but I also joined those protests and through my college years as well.
What was it in your upbringing that made you so interested in becoming active in civil rights and the anti-war movement? Was it part of your religious background? Was there part of what you learned from your parents? Where did that come from?
I think there were several influences. One was the rabbi in my synagogue was a leader in the civil rights movement, marching with people of color to desegregate facilities in Baltimore. And another shaping influence was that the memories of the Holocaust were still quite vivid in my world, in my community. People talked about it a lot. My parents refused to buy German or Japanese products for many, many years. And the way in which Jews had been subjected to genocide raised an awareness in my community of other kinds of injustice. And certainly Black people and indigenous people here in the United States have been subjected to genocidal violence.
Well, thank you, David. Let's move on from that era and those conversations to your education. After you got out of high school, you went to Princeton University and you studied English there, as I recall.
Yes?
And how did your undergraduate years affect the path that you ultimately followed into alternative dispute resolution and litigation? And what activities were you involved in as an undergraduate as well?
Uh, well, let me say a word about Princeton. When I arrived there in 1965, it was still predominantly a school that, first of all, was all male. A very high percentage of students came from prep schools. I came from public high school. And the Jewish population was very small. I'll tell you a quick story about that. I have had sort of a lover's quarrel with Judaism my entire adult life. It probably started shortly after my bar mitzvah. But when I got to Princeton, back in the days, we didn't have computers. And so when you arrive for registration, you fill out index cards. And there's one for the phys ed department, and there's one for the chaplain, or religion. There's one for the health department, et cetera, of the university. And on the religion card, it said what religion, and one of the boxes was none. So at that moment in time, I checked none, and I got a call. This is early in my first year at Princeton. I got a call from the Jewish chaplain, from a rabbi, who I guess he had a part-time gig at the university. And he said, welcome to Princeton. He said, I noticed on your card you said religion none. And I was just wondering, are you were you raised Jewish? And I said, yeah, I was. I don't know if he got that from my name or what criteria led to his calling me. So he said, okay, well, and he mentioned that there was a quota, and that, and I believe it was 20%, that they capped the Jewish enrollment at Princeton at 20%. And I had been counted toward the 20%. I guess he wanted to make sure that he got his full quota, and that he didn't admit me thinking I was Jewish, and then it turned out I really wasn't. And he was entitled to one more spot in the roster. And I was, part of me was shocked, but part of me was accustomed to the fact that, yeah, there's anti-Semitism in the world. I grew up in Baltimore. There was a country club about a mile from my house that had the best sledding hill in the winter, but it's a country club that didn't allow Jews. In fact, the entire neighborhood, Roland Park, had restrictive covenants. A Jewish person could not buy a house there up until that restrictive covenants were struck down in the late 1960s by the courts. But when I grew up, no black people, no Jewish people could live in Roland Park. So when I got to Princeton, the idea that there was a quota was not welcome news, but didn't totally surprise me. So number one, I got to Princeton and I feel like an outsider. The war in Vietnam is going on. There's a lot of complacency among the students, the faculty, the institution as a whole. And so I majored in political protest, and I minored in higher callings, various experiments with psychedelic drugs, and because I thought that those kinds of drugs were kind of a pathway to spiritual enlightenment of some kind.
But you're using higher in a little different sense than
Yes,
we use it on this podcast.
Precisely. I know that was not your intent when you
No.
came up with the term higher callings. But, and I mean, I also studied. It was a humbling experience to go from being, a good high school student to being, I had to run a lot faster at Princeton to keep up with the pack. But I graduated and went on to graduate school. So I guess I did all right academically.
Well, you did very well academically, and we'll continue talking about your path a little bit. From Princeton, you went on to Cornell, is that right? Directly from Princeton to Cornell. And you were in a graduate program for American Studies, which, as I mentioned to you when we talked, it was a program I actually looked at. When I was in college, I was thinking of applying to that program. I ended up not doing it, but it was a very well-known, well-regarded program in American Studies. What were you thinking at the time? What motivated you to go into American Studies as a graduate student?
So it seemed to me that universities back then were an important fulcrum for social change because the students arrive with a lot of idealism and a lot of energy, and it's an opportunity to really shape people's views. And there was so much that needed fixing in the United States. I mean, the United States was the most powerful nation in the world, still is. When the United States and the world stage, for the most part, when the United States says jump, the other smaller, less powerful, less wealthy nations say how high. And so to change the policies of the United States, which was engaged in what I think can fairly be called imperialist wars around the globe, Vietnam being the most prominent example, but there were certainly others, interference in the internal affairs, Chile and Nicaragua, Iran, Grenada, and elsewhere. The United States was accustomed to throwing its weight around and getting its way, and I wanted to change. I wanted things to change, and I thought being a college teacher could contribute to that. And what better subject if you're trying to change America than American Studies? And so the components of my doctoral program were um, history, literature, and African American studies. And I thought the combination of those three would help me um, learn more about what makes America tick and how to fix it, and give me some tools for teaching others.
And then you got I believe, a master's degree, but you were in a PhD program.
Right.
So something happened during the 1970s that affected your trajectory as a graduate student. You want to talk about that a little bit?
Sure. So I took my doctoral exams and passed them, but during that year, my first marriage broke up, and it was a pretty stressful year. And typically, you take your doctoral exams after 3 years, which I did, and passed them. Then the next year, you're supposed to write a dissertation. Well, that was the year of the unwinding, of a year-long unwinding of my marriage. And I think I kind of soured on the idea of becoming an academic. When I told my doctoral committee about what I was going through personally, they were not really that, curious about it. And I just, the entire academic structure of the university seemed like kind of a lonely place. The professors seemed to be not highly collegial. They each worked in their own silos. And it wasn't the kind of community that I longed for. At the time, I was living in a commune, so I was getting my need for community satisfied there. It was a commune that we created a free school. And so while I was in graduate school, I was also teaching these young kids. That part was great. The community part was great. But I never wrote the dissertation during that year. I spent time in therapy trying to get myself pulled together. At the end of that year, my fellowship ran out, and so I thought, well, I need to make a living. I set up a woodworking business, did that for 7 years, and I thought I'll write the dissertation in my spare time, which I never did.
But that didn't happen. Wasn't there also some kind of funding issue about the graduate program too?
Yeah. So when my fellowship ran out after the fourth year, it used to be, before the Nixon administration, that graduate students could kind of stay on a fellowship for quite a few years while they wrote their doctoral dissertations. Nixon ended that. And it propelled me in other directions. And we'll get to the end of the story at some point as we discuss this path that I've been on. But as I look back, I don't feel regret. I feel that the changes sent me in a direction that ultimately was very satisfying.
And you mentioned, I think you mentioned woodworking.
Yes.
You started a woodworking business, and I want to just spend a couple minutes on that. You stayed in Ithaca, New York.
I did.
During those, how many years were you there after you finished the graduate program?
Yeah, so after my 4 years of graduate school, and I did some teaching in that fourth year, which was very satisfying. I spent 7 more years in Ithaca creating and growing a woodworking business. Ultimately, I sold it to fund my going to law school. Interestingly, one of my best friends at the time bought the business, and he had gone to law school. And after he graduated from law school, he decided he never wanted to practice law. And he thought I was crazy to sell a woodworking business to go to law school. And I thought he was crazy to buy my business, but we both were better off.
So you traded places, basically, it sounds.
Exactly.
And you were in Ithaca. So you and I think we figured out that we were in Ithaca. Our years in Ithaca overlapped because I went to Cornell Law School, and you were in Ithaca at the time operating the woodworking business, which was called Knock on Wood.
Correct.
Right?
Yes.
And where was it located? What street was it on in Ithaca? Only people who have been to Ithaca are going to care about this, but I still am trying to remember.
It was on the Trumansburg Road, which is the road out to Trumansburg, which is a little farm town. It's now become more of a suburban town. And Don, you were at Cornell Law School from what year to what year?
76 to 79.
Yeah.
So we overlapped. You were done with your graduate program. You had completed the 4 years by the time I got there, I
Yes,
think.
in '74. So, um, but, yeah, so I was living the life of a hippie woodworker and a member of a craft commune. Handwork was a store in downtown Ithaca where we sold our wares. And and along the way, I met, I, I married. I got married in in the chapel in Annabelle Taylor Hall, which is part of the law school campus.
I know it well.
Yeah, and then shortly after getting married, moved to the Boston area to go to law school.
What what drove you to decide to go to law school at that point?
Well, it's a
And now we're in around 1980,
yeah,
1981.
exactly.
Okay.
Yeah. So making a living as a woodworker is possible, even if you're someone with modest skills like me, if you work hard enough. And I was sort of a self-taught woodworker. I'd watched my father, who was an amateur woodworker, metalworker. He was a dentist, but in the evenings he would tinker. And I picked up some things from watching him, but mainly I was self-taught and not highly accomplished. And it's also dangerous if you talk to, or woodworkers who've been doing it their whole lives. They're usually missing, part of a digit, or they've had some other marks of the toll that takes on people. And but that wasn't the main reason. The danger worried me a little bit. Um, but I felt like being a woodworker, well, it felt very authentic, down to earth, was not really changing the world much. And I really wanted to get back to the project of how do I make the world a better place. And I thought of two careers that might have felt that would, I think, would have felt satisfying. I thought that at the time. One was law, and one was becoming a psychotherapist. And I chose law because the path is very clear. You go for 3 years, graduate, you can get a job. As a psychotherapist, if I wanted to get a PhD in psychology, well, there I was back in another PhD program. And also, I was then in my early 30s, and I didn't feel like I had the wisdom that I think a good psychotherapist should have. I thought, well, maybe later in life I'll transition from law to psychotherapy. Little did I know that the practice of mediation would really draw on both of those two paths. But I chose law, and I had a child at the time. I anticipated having additional children. So being able to make a living was also a factor, wanting to be able to save for my kids' college, et cetera.
All right. So yeah, and I know we've talked about, and we'll get to this later, I think, how psychology enters into
Mhm.
your practice of mediation. So I am going to be interested in having you talk about that. But so you went to Harvard Law School. You did quite well. You were on the law review.
Mhm.
You were a research assistant to Professor Lawrence Tribe, who
Yes.
everyone recognizes, or most people, I think, who have heard of him recognize him as one of the foremost scholars of constitutional law in the United States, and he has been for quite a long time. Um, and you also, I think, were a teaching assistant to Professor David Shapiro,
Yes.
who I researched him a little bit. Because I was less familiar with him than I was with Professor Tribe, and didn't realize he was one of the editors of the Hart and Wexler book on federal courts, which anyone who has studied federal courts in law school has probably had that book.
Right.
So he was quite an influential professor himself. Um, and I'm putting that in the past tense. I don't know whether he's still with us
Yeah.
or still.
He's
Okay.
passed on, sadly. Yeah.
Um, so you had some wonderful opportunities at a magnificent law school and did quite well there. And at the same time, you were still a bit of an activist, I think. What were you doing while you were in law school in that realm?
Well, there were two main areas, politics that were going on at the law school then, outward looking, and one that was more inward looking. The two outward looking ones, one was divestment from companies that did business in South Africa, and there was a major campaign to get Harvard to divest, and other universities at the time. And the other was the brewing conflicts in Central America and trying to get the United States to behave in a more responsible way in terms of our relations with Guatemala, Nicaragua, El Salvador, and other countries of that region. The inward focus, there were protests at the law school while I was there, and I was part of them, to make the law school more racially diverse, to add more women, and also to reform the climate of the law school in various ways. Interestingly, my work with regard to Central America spilled over into my career because it turned out that one of the companies that I was promoting a boycott when I got my first job at Hill and Barlow. One of those companies showed up at Hill and Barlow's door as a potential client, and I raised my hand and said, "Well, wait, they want to fight this boycott activity. I'm involved in the boycott." And I really admire what Hill and Barlow said, which was that you were engaged in the boycott activity before the client came. That is clearly a conflict of interest, and we'll turn down the client if you intend to continue with the boycott. And I said, I do. And it's one of many things that I really respected about.
Yeah, and we'll talk about
Yeah.
about the law firm because it really was a very interesting law firm.
Yeah.
But I think what that does is that really reflects on a couple of things. One is the high ethical standards that they applied, but also how they cared about the people that worked in the place. I mean, you were not a partner at the time, I
Oh,
assume. You were an associate
first
and
years.
a first year associate. And so for the firm to turn away what might have been a significant piece of business to honor the activities and inclinations of a first year associate, that's really extraordinary in my experience.
I quite agree.
Yeah. So, so you were involved in the divestment activities of students at Harvard Law School, I assume, or Harvard University, maybe
Yes,
more broadly.
correct.
And I recall those days, and I recall that those activities were happening all over the country on a number of university campuses. I think they might even have been going on at Cornell while I was still there. That would have been the late 70s.
Mm-hmm.
Maybe that was
Yeah,
the early days of the
it was.
of that kind of activity.
And also at BU, in one of my first cases as a lawyer, was defending a BU student named Josef Abramowitz, who had a sign in the window of his dorm at BU that said "Divest Now." And unfortunately for Josef, or actually ultimately unfortunately for BU, his window faced John Silber's office. And so
Oh.
President
For
Silber,
people who don't know, he was president of Boston University and later became a candidate for governor of Massachusetts, which he lost, I think, to Bill Weld at the time.
that's correct. It's the only time I've
Yeah.
ever pulled a Republican lever in my life. Because I was involved in the ACLU suit against John Silber and in support of Josef Abramowitz. The ACLU took this case because what Silber did, he told the security forces at BU, the security team, to go to this student's dorm and tell him he had to take the sign out of his window, "Divest Now." And they said, well,
So a little bit of a free speech issue, it sounds like.
precisely. And
Yeah.
and the security folks said, well, what if he refuses? And they said, well, then you're going to have to evict him from the dorm. And they did.
Wow.
And so we sued and we won. We won an injunction. It was one of the first cases in which the Massachusetts courts applied our civil rights statute, which prohibits violating, infringing on constitutional rights by threats, intimidation, or coercion. So it basically creates a private right of action for rights that would otherwise be only usable against the government. And
In other words, you can sue a private party.
yeah,
You don't need governmental action to trigger what otherwise would have been a constitutional issue. This is a legislation that actually creates the same kinds of rights against private parties.
precisely. And so back in the 70s, the late 70s, when you were in law school, the divestment movement was developing, the anti-apartheid movement, and it continued until the mid 1980s, which is when the Abramowitz versus BU case was filed.
That's really interesting. I guess we both grew up. You might have been a little bit ahead of me, but we both grew up in quite an era of very interesting political activity, not only in the United States but around the world. And but you were very focused in both aspects of it on racial equity, which I applaud you for doing that. And all that activity around the country and around the world ultimately did help bring about change in South Africa and other places. So, from Harvard Law School, you went on to clerk for, at the time, Judge Stephen Breyer. He had been appointed to the First Circuit Court of Appeals, I believe, in about 1980 or 1981. I think late 1980, if I remember. I think it was a little after I completed my clerkship with Judge Toro in the District Court in Massachusetts. And I mention that only because I think we might have had offices in the same floor of the same building, although at different times. When I clerked for Judge Toro, I think we were on the 16th floor of the John W. McCormick Post Office and Courthouse building in Post Office Square in Boston. And if I remember right, when Judge Breyer came, now Justice Breyer, came to the court, which was maybe just a couple months after my clerkship ended, I think he was down the hall from Judge Toro, if I remember right.
That's right.
Does that sound right?
Yes.
Yeah. And so that was a one-year clerkship, I assume.
Yes. The family of clerks, the community of clerks for Breyer gathered before the pandemic. It was the fall before the pandemic for the 25th anniversary of his being on the Supreme Court. And it was quite wonderful to see all the clerks. And he came over. I introduced him to my wife and gave her a big hug. And this was all in the hall of the Supreme Court, so it was quite grand. And Breyer has stayed in touch. I get a Christmas card from him every year. He's been very good at keeping us clerks united as a community.
He had been a professor at Harvard Law School. Was he one of your professors? Did you take any courses with him?
No, I didn't, but I'll tell you a funny story. Back in the 1980s, a lot of law students called their professors by their first name. And I was one of the older students, and I was very comfortable with that. I don't remember if everyone did it, but because he was a professor there, I would have called him Steve. So on one of my first mornings as a clerk, I get on the elevator at the courthouse building that you described. And
notoriously bad elevators there at the time, as I recall.
Exactly. And I get on the elevator, and there were several employees, and Judge Breyer was on the elevator. So he had already gotten on because he came up from the garage. And as I got on, I said, he said, "Hi, David." I said, "Good morning, Steve." And suddenly the elevator just got completely quiet. You could hear a pin drop. I had violated the norm that you never call a judge by their first name, even if you happen to have met them when they were a professor at the law school that you attended. So I never made that mistake again.
That's really funny. I clerked, as I mentioned, for Judge Joseph Toro who passed away just a couple of years ago. He was a fairly young judge when he was very young when he was appointed, and there were certainly people who knew him before he became a judge that called him Joe. But I never would have even dreamed of calling him anything other than judge.
Yes,
But I also didn't go, he wasn't a professor at my law school either. So,
but it is
um,
an interesting convention of the legal profession, in my experience, that if you knew someone before they became a judge, it's totally okay to call them by their first name. And if you met them for the first time when they were a judge, they will always be Judge X, forever and ever. At least that's
no, that's really true. And I go to events and I see judges, or now some of them are retired judges, who I had known in private practice when they were just lawyers and not judges. And I always knew them by their first name. And when you're in a public setting, you sort of have to catch yourself because some of them want you to still refer to them as judge in public, even though in private they're happy to be called by their first name. But with Judge Toro, I was always confused because when he would write a note to his law clerks, he would use your first initial and then he would sign it with his first initial. And I never knew if that was Joe or Judge.
huh.
He was signing it.
Yes.
But you had a wonderful clerkship. I mean, what a great opportunity to clerk for Stephen Breyer, who did go on a few years later to the United States Supreme Court, and it's still there today after all these years.
So very down to earth in that way, and also in spite of the fact that he's a formidable intellect, he writes opinions so that they're understandable. His aim is to write in such a way that someone with no more than a high school education would be able to understand what he's written. And I truly admire that. And I think it reflects a deep democratic spirit.
He tries to make the law accessible, and it's also the teacher in him.
Mm-hmm.
I think you can tell when he speaks that he's really trying to teach the audience more than anything. So, well, what a great opportunity that had to be. Now, from there, you went into private practice. And I'm sure coming out of that clerkship and with your academic credentials, you could have chosen from any large number of law firms in Boston. You decided to stay in Boston after law school, obviously. Um, why Hill and Barlow? What drove you to that firm in particular?
Hill and Barlow was not the biggest firm in Boston. I think it was number 10 approximately in terms of size. But in terms of stature, it was a notable firm because it had several former governors, Dukakis, Weld, and later Deval Patrick.
Right.
And when I arrived at the firm, one of the partners, Mike Greco, was head of the Mass Bar Association. Another partner, Dick Renan, was head of the Boston Bar Association. Many of the partners taught in law schools, did a lot of public service work of various kinds. And so I had some wonderful mentors. But I think the two biggest factors for me, aside from good quality work and good quality training, the two biggest factors were, number one, they permit pro bono work. And I represented a guy on death row in Louisiana. I did some ACLU cases. The firm was very proud of its pro bono work. The pro bono hours we spent counted toward our billable hours, which I thought was a commendable policy. The second reason was it was a firm, died in the year 2002. The firm was very supportive of people having a life outside of the office. After I received an offer from Hill and Barlow, I said, well, before I accept the offer, can I come back for a second round of interviews with the associates? The first round of interviews was with the partners, but I said, I want to talk with the associates. And they said, sure. So I set up some interviews, and one of the questions I asked was, what's the divorce rate at Hill and Barlow? And I was told that it was very low.
That's a good sign.
Yeah, and that was, I thought that was an important metric. And I asked about whether the firm was serious about, the commitment to pro bono. They said absolutely. And they said, in addition, the firm supports associates who do not want to work on a specific case because they have moral compunctions. Our firm represented an accused Nazi who was fighting extradition from the United States, and there was very strong evidence that he was part of the Nazi regime, and I was not going to be able to represent such a person, having lost family members in the Holocaust. And there were some other cases as well that I said to the firm once I was there that I was not willing to work on, and that was fine. I became a partner. It wasn't held against me in any way. And as you mentioned earlier, the firm had high ethical standards and supported its associates in ways that I thought were impressive. Before we leave the subject of Helen Barlow, I just want to mention two other mentors who were important to me.
Sure.
One was Nani Burns, who went on to Superior Court.
Oh, yeah.
And she was one of the leading partners in Hill and Barlow, and one of my mentors. I had the good fortune of working with her on cases. And she was a very strong advocate for gender justice, not only at Hill and Barlow, but in the world. And Reg Lindsay, who was also one of my mentors, who became a judge. He was a federal district court judge, and sadly has passed on. An African-American judge who also spent his adult years, most of them in a wheelchair, and so was an advocate not only for the rights of people of color, but also people with disabilities. And those two were very important shaping influences for me, and they were both superior, terrific lawyers.
So, David, you started doing mediation while you were at Hill and Barlow.
Mm-hmm.
How did you get started in that, and why?
So, if your reason to go to law school is making the world a better place, at least in my time, graduating from law school in 1984, I thought the way to make the world a better place was litigation. That's all I wanted to do. I went to Hill and Barlow just to be a litigator. I said, don't rotate me through corporate and tax and real estate and any of those other departments. And they said, okay, you seem like you know what you want to do. One of the older associates. That's all I did. But once I saw what litigation actually was like, I became aware of how inefficient it was and how it often produced results that were suboptimal. As you and I both know, there are things you can accomplish in mediation that cannot be accomplished in a courtroom. Now, that doesn't mean cases like Brown versus Board of Education should go to mediation. Obviously not. They're important test cases. But the routine commercial family employment cases that occupy the meat and potatoes of litigation departments in law firms can be resolved much faster, cheaper, and better in most instances with mediation. And so when I saw these inefficiencies, I said, I need to go back to look at the things that I scorned in law school, because ADR was starting to bubble up into visibility when I was at the law school. In 1981, when I started law school, Frank Sander started the first 3-credit mediation course at Harvard Law School. Roger Fisher was just beginning to teach the negotiation workshop. I didn't take any of those courses. All I wanted to do was litigate. And I went back and saw, gee, I missed an opportunity there. I need to study about this. And because back in the early 1980s, ADR was viewed as suspect. It was viewed as a tool for the powers that be to privatize justice, sweep injustice under the rug of privacy and confidentiality in mediation and arbitration. And my view, and the view of many people who espouse progressive values, was no, we should do this out in the open. But what I came to see is that, yes, there are some cases that have to be out in the open, and others, let's learn the tools of mediation. So I called Frank Sander. He had been my advisor in law school, and he gave me a path. He said, start an ADR practice group, get trained as a mediator, get trained as an arbitrator, And I did those things. And he said, try to get on panels. I did. And I was fortunate enough to get cases referred from these panels. And Hill and Barlow was the ideal place to be because there were others at the firm, like Mike Greco and Joe Steinfeld, who were interested in this, Carl Sapers, and they supported me. And Hill and Barlow was willing to let me do these cases at the cut rate, court referred fees. And I respected the firm for allowing me to do that.
And then at some point, you left Hill and Barlow, I think around 2002.
Yes.
Which, as I understand, it was maybe just a few months before the firm dissolved.
Correct.
But you left because you wanted to start your own mediation practice.
Exactly.
And tell us a little bit about that. What did you want to do on your own that you felt you could do better in your own setting rather than as a lawyer in a law firm?
Well, one of the things I wanted to do was to have a multidisciplinary practice and involve therapists and financial professionals in the work, because most of the cases, not only the family cases, but also the business and employment cases, often had tax implications, they had psychological and emotional implications. And so one of my goals was to create a team at Boston Law Collaborative that brought those skills to the fore. Another thing that I really yearned for was going back to my commune days, is to work in a place that felt like a community. Now, Hill and Barlow did feel like that when I arrived, a rather large community. But as the firm grew and took in lateral partners, the culture of the firm wasn't quite the same. It didn't have that same feeling of connection. I discovered that at Boston Law Collaborative, with a much smaller cohort of people, get to know each other better and have a much higher level of collegiality. A third thing that I wanted to do was focus primarily on conflict resolution. The downtown law firm business model doesn't really support that because someone comes with a big, complicated commercial case and they want it litigated, saying, "Well, why don't we just represent them for negotiation? We'll use a collaborative law model or a settlement counsel model." No, we're not going to do that. It doesn't make any sense, financially to do that. So the incentives for a big firm, I understand them. I'm not. This isn't a judgment. It's how one sector of the U.S. economy finds its legal needs being met. But I think we're seeing much more mediation of these commercial cases now for good reason. And the firm still, can survive because before you get to mediation, there's often a lot of discovery that needs to be done and some motion practice to shape the case. So mediation isn't the death knell of commercial litigation, which you and I have practiced.
No, and clients in many cases drive their lawyers to explore and advise them about possible settlement.
Yeah.
Just because of the long time it can take to get a case to trial and the amount of expense involved. So I can't think of very many cases I've had where we haven't explored potential settlement, and often we do that through mediation. But I'm sure there are other cases I've handled and that other lawyers handled that where no, it's we want to try this case. We are concerned about the legal precedent. There's a lot we could talk about on this, and I don't want to distract us too much from what you do and what the Boston Law Collaborative does. The very name is kind of interesting, though. Why collaborative?
Well, it has a double meaning in the context of our firm. One is that we do try to work with each other inside the firm in a highly collaborative way. And what do we mean by collaborative? Well, one definition supplied by some social scientists named Thomas and Kilman. They created the Thomas Kilman conflict mode instrument. And they describe collaborative style of dealing with conflict as caring a lot about relationship and caring a lot about results. And that's what I see as a collaborative style. The other meaning is that we are involved not only in mediation and arbitration, um, but also collaborative law, which is representation without litigation.
And that's a term that a lot of lawyers aren't familiar with. In
Yes,
fact, I don't think I would be familiar with it, except I've heard you speak about it. Um, so tell us what collaborative law is and what you see as the benefits of collaborative law.
sure. So collaborative law began in the year 1990 in Minnesota with a lawyer named Stu Webb, who was a family law attorney and was kind of sick of all the heartache and expense that divorce litigation caused. And so he got trained as a mediator, but he wasn't really satisfied being a mediator because he saw that his clients really needed legal advice. And if he was the mediator, he couldn't advise the client. So he came up with an idea, which is I'll represent my client, but only for negotiation. And I'll see if I can line up another lawyer who's willing to make the same commitment. And that way, everybody, the clients, the lawyers, their interests are economically aligned toward resolution. Because if we can't settle the case, they have to go to court, they have to hire new lawyers. And Stu found this to be an extremely satisfying way to practice, and it produced excellent results because it changes the dynamic in the negotiation room if you're sitting across the table from a lawyer who you're never going to have to face in court. And everybody is focused on settlement. So this movement has really taken off. Tens of thousands of lawyers and also financial professionals, mental health professionals have been trained in how to use collaborative techniques, which involve cooperative negotiation style, sharing information.
When you say it's taken off, did it take off recently or did it take off from the very beginning in the 1990s?
No, it had kind of a slow ascent. It didn't reach Massachusetts until 1999. And the way it got here was a lawyer friend of mine, Rita Pollack, and I were talking about it. We had been reading about it and hearing about it. We said, why don't we invite some folks to come and have bagels and coffee with us some morning and see if Massachusetts should have a collaborative law group. At that time, there was one group in Minneapolis, one group in the Bay Area, California, one group in Cincinnati. And we became the fourth place in the United States. So people came to Hill and Barlow because Hill and Barlow is very good about hosting events like this. And the Massachusetts Collaborative Law Council got launched. So we are now in our 21st year as an organization. It's taken off primarily in the family law area, but it's a technique that's used to some degree in business cases also.
And how does it work?
Well, someone comes to me and says, I'd like a collaborative divorce. And I say, well, here's a list that your soon-to-be ex-spouse can look at of other collaborative lawyers. That roster, our membership in the Massachusetts Collaborative Law Council, is one of the most important tools in the toolbox of collaborative law, because now the other party is going to hire a lawyer who's collaboratively trained and committed to collaborative practice. And then the other lawyer and I will get together for a cup of coffee or over Zoom nowadays and just talk about, the case and get to know each other a little bit if we don't already know each other, and make some plans for a four-way meeting. Sometimes, if it's a highly emotional case, we'll hire a coach. So we have two lawyers and a coach. Sometimes just
So that the coach serves kind of the same role as a third-party neutral in a mediation? But
absolutely
you don't serve as the coach yourself, or do
no.
you sometimes do that? You only represent a party in the collaborative
That's
process.
right. Yeah. And then
Okay.
we sit down and we sign an agreement that says the lawyers are in this only for negotiation. We begin to plan out the exchange of information. We talk about any near-term front burner issues that need to be resolved, right away. And we set an agenda for some meetings. And my goal, representing a client in a collaborative case, is not only to make sure my client's needs are met, but to make sure that when we're all done, there's no unfinished business, and these two people can leave in peace. Not only peace with each other, because they may have kids, they may have to be co-parents, but peace inside, that they've made an well-informed judgment about what's best for everyone. And no one's arm was twisted. We did this voluntarily. And it's been an extraordinary gift to many families. And I get cards from people who, former clients, who are just so grateful that they got through what for many people is extremely painful, acrimonious, divorce. And they came out and they're still friends with their ex. So
it's part of the lawyer as peacemaker model.
Absolutely.
Doing collaborative law. What's the success rate of collaborative law cases?
Yeah, it's very similar to the success rate in mediation, and it depends on who the mediator is and who the collaborative lawyers are. But the middle of the bell curve for both mediation and collaborative law is somewhere between 80 to 90% success.
And the idea is that if you're hired to be a lawyer in a collaborative law case, you're only there to negotiate and try to achieve an amicable resolution
Yes.
of the dispute. If it doesn't resolve and it ends up going to court, you don't get involved in that. They have to hire another lawyer to represent them, right?
Precisely.
Okay. And we've mentioned mediation a few times. We're assuming everybody knows what mediation is, but there may be people listening who don't know what mediation is. And why don't I let the expert? I mean, I know what mediation is, but why don't I let you define it rather than me doing it?
Well, so the shortest definition of mediation that I know is facilitated negotiation. You hire a mediator to be the person who keeps the negotiation on track. But more recently, I've become persuaded that another two-word definition is also a good one, which is assisted negotiation. Because often the mediator adds value by making suggestions. And one of my colleagues in teaching mediation, Larry Susskind, says that his view is that he has a job not just to make sure a settlement occurs, and that is what he's been hired to do, but that he has a responsibility for helping the parties reach an agreement that is fair, efficient, stable, and wise. Now that's a big mission. Fair, that's up to the parties to decide. And efficient, well, yeah, if we stay out of court, we meet that objective. Stable, yes, mediators sometimes say, well, okay, wait a sec. I see a potential problem in this settlement. Let's talk about how this will be handled. And so we can help people have more lasting agreements. Wise is the really interesting one. And what he means by that is that maximum value has been achieved. If you've got an omnivore or a carnivore who's got an abundance of broccoli and a vegan who's got an abundance of lamb chops, you want to optimize the trade. And so you want to figure out what people's interests are so that they can both be better off, expand the pie, joint gains. And Larry's point, and I agree with him, is that mediators sometimes underutilize the position that we have to help people come up with even better deals than the ones they would arrive at left to their own devices.
And I think for people who don't understand it, it's also important to emphasize that mediation is a non-binding process. So it's not like arbitration where you are bound by the decision the arbitrator reaches, which is similar to what a judge might decide in a case. But it's really an effort to see whether you can settle a case. And if it doesn't settle, nobody is bound by anything that happened. You just go back to litigation and see what comes of that.
Precisely.
So,
yep.
And you've taught me a little bit too about something called the internal family systems model.
Yes.
And for people who really want to get into the weeds, I don't want to spend a lot of time on it, but can you just give us a very high level overview of what that is and how you use it in your practice?
Sure. So the backstory here is that as I got more deeply into mediation, I began to see how ill prepared I was to deal with the emotional and psychological dimensions of conflict. I didn't have any training in psychology, even though I had been drawn to the idea of psychotherapy, and even though I've been a consumer of psychotherapy services at times in my life. I didn't really understand how to use the insights that therapists have. And so I spent a lot of time talking with therapists, some of whom are mediators, trying to learn from them. And the models that psychologists often use are, in my mind, kind of alienating in a way, because they say that there are high functioning people and there are others who aren't. There are some people who have characterological disorders and people who don't, and there are diagnostic criteria and so forth. And so I thought, gee, I need to learn more about the diagnostic criteria. And how do you work with someone who has, say, a narcissistic personality disorder? And then I learned about this other way of looking at things. The internal family systems model posits that we are all quite similar, actually, in having multiple parts. We have a part of us that likes to work hard. We have a part that likes to play. We have a part that is loving. We have a part that's fearful. We have optimistic parts, pessimistic parts. And the internal system of how those parts interact with each other has a big influence on how we make our way in the world. And when we see people in conflict, it's often because they have some wounded part that got re-injured, and their angry protector parts are out there throwing accusations to defend that wounded part. It happens to all of us. And learning that model has helped me be more compassionate for the people that I work with, because I can see in them the same patterns, dynamics that I see in myself. And also gives me some tools for how to encourage them to get those angry gladiator parts to just take a step back, make room for some problem-solving parts. And also the model posits that we all have self-energy, which the faith traditions would call spirit or soul or heart. That self is like our internal mediator. And so this model has helped me see that I can actually have heart-to-heart connections with people that are within my job description. It's not like I'm taking on the role of psychotherapist. I'm not. But I can try to get my angry or defensive parts or worried parts to take a step back and just be authentically present for people. And when we do that, it can open up space for them. When we can encourage them to get their parts, take a step back. And having that heart-to-heart connection with people often can pave the way for not only a resolution, but a resolution that they feel peaceful about.
So all of these different approaches, collaborative law, mediation, application of the internal family systems model in what you do, all of that seems to me to be a reflection of a way of going above and beyond what many dispute resolution people or professionals or firms do. And it seems to me somewhat reflective of who you are as a person, and you're holding up this ideal of lawyers and mediators as peacemakers, which is what you talk about in that TEDx talk that I saw on YouTube. Maybe we can wrap this up by just having you talk a little bit about what advice you would give lawyers, young lawyers, litigators, parties to disputes. I'm making this pretty broad, but of how these types of processes can be used really to contribute to a more peaceful world and improve the lives of the people who are parties to these types of disputes. Pretty broad question, but I'll throw it at you, and I'm sure I'm very interested to hear what you have to say.
Well, it's an excellent question, and it sort of points at an intersection of social justice and peacemaking that I'm still trying to figure out. And I'm certainly not the only person who's trying to figure that out. Because on the one hand, making the world a more peaceful place without justice is impossible. Ultimately, the injustice.
No justice, no peace is the slogan I think I hear quite a bit, and it makes a lot of sense.
Precisely. And so it seems to me working on both fronts is important. Peacemakers can bring to the table some of the tools of dialogue and good listening and building understanding that can pave the way for broader justice in our society. That said, there are injustices that simply need the pressure of protest and concerted activity. And I don't think those two initiatives, peacemaking on one hand and fighting for social justice on the other, are mutually exclusive or even contradictory. And my mission in life is to make the world a better place. I got that from my rabbi as a young kid, and I think we can make it better by making the world both more peaceful and more just.
And that's what you seek to do in your practice and the people who work with you as well.
Absolutely. And I feel like it's a challenge that will be with me for my entire life. It's and in keeping with the title of your podcast, Higher Callings, I think that for lawyers and other professionals who might listen to this conversation, I hope that they feel like they can practice their work in a way that feels like it does have that higher calling, that deeper meaning, and not only in terms of what we experience in our own life in doing that work and the impact we have on people, but also the ripple effects that will outlast us and outlive us. And for that, teaching has been a really valuable avenue of endeavor. But I think that in every one of our cases, we produce ripple effects. We change the world in every one of the conflicts that we help people resolve.
David, thank you very much. This has been fascinating. Every time I talk to you, I'm fascinated by what I learn. And I'm sure that people who take the time to listen to this podcast will appreciate it as well. So thank you for taking the time. And I look forward to seeing you around as we get back onto the streets of Boston and maybe into the mediation rooms and not just the Zoom videos.
Yeah.
I hope to see you before too long in person and to have many more years of this type of collaboration.
Yeah.
So thank you.
You're welcome, and thank you for the invitation. And I learn a lot every time I talk with you, Don. So thank you for this conversation.
Thank you, David. I appreciate that. Take care.
Bye-bye.
This has been an episode of Higher Callings. Your host is Donald Federico. Music is provided by Fancy Mountain, and our logo was designed by Matt Pedro. Higher Callings is edited by Brian Federico. Higher Callings is a production of Federico Media, LLC.